Hey, Kristin, thank you so much for joining me today. I am so happy to have you on here. I needed to get the word out about like trusts and probate and all that fun stuff. And so I looked up the best professional I could find and found you.
Thank you so
Um,
much for having me. This is such an honor.
for sure, for sure. And now, when I first met you, you were with a different firm, or you were partners in another firm. But
Yeah,
what happened?
partners. Yeah, and so then we just decided my partner was going to focus on his area of expertise, his niche, and I was going to focus on mine, which is estate planning and probate and trust administration. And so we decided to create two separate firms. And so now I have my own firm, Kaminski Law Group, and I have a wonderful associate attorney who helps me out every day, Rick Lebhers. So
Yeah.
so this just started less than a month ago, and here we are.
Nice, nice,
Yeah.
awesome, awesome. And how long have you been doing this?
I have been practicing since 2011, so a little over a decade. I started in Nevada, actually. So it's kind of helpful because I have several clients who have, Incline Village properties, or properties in Reno, or Las Vegas. So I can help out the California clients that have additional property in Nevada. So started out in Nevada, moved over here to Sacramento, loved it, would just never looked back. And so here we are.
Yeah, so that's kind of cool that you just told me that. So if I have somebody that's in Nevada, and which I do, like I'm always referring people up there, and they may need to change over some things, estate stuff. Is that kind of a common thing? Because I know my parents just moved to Arizona, and they had to have kind of their trust and stuff redone in Arizona. Would that happen in Nevada?
Nevada, I recommend at least going to look with an estate planning attorney at your documents just to make sure that there's nothing that you're missing. If you created a California document, for instance, going to Nevada, you could have some different laws. There are a little bit of distinctions in Nevada. It's not too much of a distinction, but for Arizona, I don't know. I don't know the Arizona laws, so I always say, hey, if
Yeah.
you're moving somewhere besides Nevada or besides Wisconsin, where I'm from and where I'm also licensed, go talk to an attorney there. And I've got a network of national attorneys that I refer out to. So they're
Okay.
all part of the American Academy of Estate Planning Attorneys.
Okay.
And this group, we all specialize in this area of law. So I'm very confident referring someone to any attorney that's in this organization all over the country.
Nice, nice, nice. So now that you said, so now you also have, you said Wisconsin.
Wisconsin,
Is
yes.
there any other tricks that you guys?
Will not take another bar exam, although I've considered Hawaii because that would be a really nice place to live.
Yeah, yeah. I should get my lending license in
There you
Hawaii as
go.
well.
Yeah, yeah, absolutely.
Things move so slow there. We bought a
Yeah.
house there, and the process is just numbing. That it takes,
Uh,
it takes 90 days, and something that you can close in 20 days or
you
15
know what?
days.
It's the lifestyle, it's the laid back. So when I was in law school, I had the opportunity, this amazing opportunity to go intern with a Navy JAG Corps. And my options were Illinois and Chicago or Hawaii, Honolulu, and at Pearl Harbor. And I said, "Oh, I want that laid back lifestyle." And I went there, and it was amazing. It was an amazing summer. So everybody's just a little slower pace there. So that
Yeah,
makes sense.
yeah, for sure. So now that you've said all the different places where you have you're a bar member,
Yeah.
so what should I be, and what should people be looking for when it comes to hiring a good estate plan?
Attorneys should specialize in this area. There are so many rules and laws. I am learning every day. There are things that I have to research that I, rely on my team of experts to help me
Yeah,
with. So being a part of the American Academy of Estate Planning Attorneys is huge for me because I get to, call senior counsel and say, hey, there's this tax issue. I don't know how this works. Can you walk me through this? Or what's the best way to word this language in this trust? Or we have this
yeah,
trust administration, what's going on? So look for someone I would recommend an American Academy of Estate Planning attorney. I would also look for in the state of California, and not every state does this. Nevada doesn't do this, Wisconsin doesn't do this, but you can become specialized in California in estate planning. And what that means is I took this test, and I had to prove to the State Bar of California that I was not only practicing exclusively or almost exclusively in estate planning, but you have to prove that you're competent in it. And you have to tell the state bar, all these different types of cases you've handled, and you have to, prove that you can handle this. So now, because I passed that test and because I proved to the state bar, I am a certified specialist in estate planning, trust, and probate law. And so look for that. And that's, those, just look for someone who practices in this area, because if they don't, they can cause you some trouble. If they're not doing everything appropriately, things can happen down the road that you might not be aware of. So that's probably what I would recommend.
So kind of a good thing for somebody that probably already has, like me, right? I already have a trust and everything
Good.
set up. What is it? But I haven't visited it in a while. So
yeah.
What should I do?
Yeah. So contact your estate planning attorney or show me your trust. And what I can do is I can look through it. And I'd say 9 times out of 10, when we have an older trust, it is a AB trust. And a lot of people have no idea what that means. And that's okay. I don't expect you to know what that means at all.
Yeah.
I look at it and I say, okay, this is a mandatory AB split. And you probably don't want that unless there are certain circumstances where you do. But in, generally every decade-old trust I see has this mandatory AB split. And what that means is that upon the death of the first trustor to pass away, the surviving spouse has to go in and divide the trust. And there are all kinds of negative things that are associated with that you, as the widow or widower, do not want to deal with. And people have no idea. So then usually when the husband passes away, it's usually the husband, sorry. And then the wife walks in here and says, what is this? Like, what do I have to do? Why do I have to do this? Well, we've petitioned the court to terminate that trust, that AB split, and just put it all to the survivor's trust. There are a lot of different things you can do after the fact, but it's way more cost effective to do it while you and your spouse are both healthy. So just go look, I offer a complimentary trust review to a non-client, to a client, to anybody, just because I want to say, hey, this is what the current law says. This is what we should be looking for. The other thing is, people put in these provisions for their kids that have like mandatory bequests to their kids at like age 25, 30, 35. Well, that's all good. But what if you don't know who your kids are going to be when they're 25, 30, 35, and you're giving them this this mandatory distribution? Well, in the trust I draft, I generally say, well, let's not give them a mandatory distribution. Maybe it's contingent upon some things. So I like to be, I like to look at it like a holistic approach, like all the different contingencies, not just giving them a mandatory right, because that could cause issues for a divorce. It could cause issues if there's special needs, if there's like somebody's on Medi-Cal. It could cause issues for a liability, a judgment, a bankruptcy, all the things you want to think about. So if your life has changed, it's a good idea to get it reviewed. So I'd probably get it reviewed. And the general consensus in the estate planning world is like every 3 years, go get your trust reviewed. Now, do I see that with clients? No, because the 3 years flies by. So I would say, every time something happens in your life, you have a new grandbaby, someone, your successor trustee passes away, and you want to, say, okay, it's time to update that stuff. Good thing to think about. Also, like your healthcare decisions, maybe your kids are of age now where you want them to make those decisions for you, or you want your kids to be trustee. Then it's a kind of a good time to just review it with your attorney.
So it's kind of funny that you said that mandatory distribution. I have mine set at like 35 and 40 because I just don't think that your brain's fully ready to go.
Yeah, absolutely. Yeah.
So I will definitely be giving you a call, and we'll be getting together.
Sounds good. Yeah, we can walk through it.
Just an FYI.
Sounds good. I'm here for you.
Also, so now I know, aren't you guys kind of limited by how much you could charge? Like sometimes I think people are afraid to get involved with an attorney because they think it's going to be thousands and thousands and thousands and thousands of dollars just to divide some things up and to make things happen. Are you guys limited, or how does that work?
So the limit would be set by the court for probate. So if
Okay.
you do nothing, or if you just have a will, the court does set a limit. Actually, it's probate code that sets the limit, and it's a court ordered statutory fees. But these limits are extraordinarily high.
Oh, okay.
So
Okay.
if you have, and the court doesn't take into consideration any encumbrance. So if you've got a mortgage on your house, the court doesn't care when they look at the value of your assets. So say you have I mean, nobody has a house worth $100,000 in the state of California. That is
Yeah. Yeah. Yeah.
So if you have $100,000 though, your probate fees are $4,000. If your estate is 200, if your house could sell for $200,000, and that is the only thing in your estate, your probate fees are $7,000. It goes up and up and up, and it is so
Okay.
expensive. So we had a $5 million probate several years ago, and the gentleman had no will. He died in his 40s, heart attack, didn't wake up. He had kids and a wife and separate property of about 5 million. The attorney's fees on that were ludicrous, and I won't forget it, because I think, oh my gosh, this poor wife. She lost her husband. She lost her kids. Or she didn't. No, she lost her husband. She lost a third of her, and she was only getting a third of his estate, because that's how it works. When you don't have a will, you only get a third, and then the kids get the 2/3.
Wow.
And so she had to deal with that. And not only that, she had to pay us over $50,000 in attorney's fees.
So meaning you need to get a plan in place before it goes
in place.
to probate.
So I have heard other law firms charging upwards of $10,000 for a revocable living trust. Now, we do not charge anywhere near that, but there is no cap on it. But so what I recommend always is do your homework and do not pay an hourly fee for estate planning, because you have questions, right? Like, you want to know, okay, is this like my son? He's kind of good with money, but kind of not. Like, do I really want to give him this like automatic, distribution when he's 35? I'm not sure. Like, let's talk through it. I will meet with you as many times as you need to be met with. And sometimes it takes 2 years to get a plan together. Other times it takes 2 days. If you're, going into the hospital for surgery, we're going to get your plan ready.
Yeah.
So bottom line, find an attorney who does a flat fee for their fees, and find someone who doesn't charge $10,000.
Yeah.
Okay. Our fees are on the lower end, but we have a whole package, and it provides a lot of, you're a part of our client family forever. And so, yeah.
Nice. So once you have like an estate set up, right? Or I'm sorry, not an estate, but once you have a trust set up, is there things that the person needs to do on their end to make sure that the things that are in the estate actually do what they say that they're going to do?
I'm so glad you asked that question, because that is what I see when people pass away. Their kids say, well, mom and dad had this trust. This was supposed to do everything. Like the legal Zoom trust. I have seen that. I have seen the trust where, you download it on the internet, you sign it. People think they're done, that they're not at all. I mean, you being in the real estate world, you know that you have to fund your trust, or fund your trust with you have to put your house in the name of your trust. You have to do that in order for it to be funded. So yes, so there are some steps you have to take. And our law firm, and we take care of the funding of the real estate. So if it's in California or Nevada, anywhere else we help you with, but it's not something that I can do, because I am not licensed in the other states that people generally own property. Otherwise, we give you assignments and funding letters and a certificate of trust, and you have to actually go. And I always explain, if you have a brick and mortar bank, you have to go into your bank and say, I have, this trust. I need to put my account in the name of my trust. And a lot of people say, okay, well, do I need to have new checks prepared? And I don't want new checks prepared. And I say, no, you don't need new checks prepared, because you're not going to get a new number. You're not going to get a new account number. And your check does not need to display to the world that you have a trust. And you don't have to do that. Some people like to be fancy and say, yeah, look at my trust on my check. No, you don't need to do that. If you want to, go ahead, but not necessary. So there is a little legwork, and we walk you through that, and that's so important. So
is that what you mean by fund your trust?
Yeah.
Is that what you mean? Okay.
Yes, exactly. And that is just a term that's used in the industry, but I know that it's kind of like, what does that mean? Like, fund my trust. But yes. So what I always explain is, you've got like, your trust is like this empty, here we go, this empty like basket, right? So it's empty. It's a beautiful little basket here, but it has nothing in it. Well, you have to put all of your assets inside of the basket to make your
Yeah.
trust
Okay.
funded and make it work for you at your death. And so we're here for you, and we have a funding paralegal that helps. And so I get a lot of emails that say, okay, so what do I do now? And then we walk them through, and any beneficiary designation form, we walk them through that too.
Okay. And ideally, what bank accounts, real estate, can you do, let's say, a 401k or
You asked that.
maybe
So
insurance?
yeah, so with a 401k, with any retirement plan, there's generally it could be some tax consequences. So as far as naming your trust as the beneficiary, so I always say, do not name your trust as the beneficiary of the 401k unless there's a good reason. And the good reason would be there's a minor beneficiary, because you don't want a minor to inherit anything because they
Yeah.
can't.
Okay.
Then it would have to go through a guardianship. The other reason is if you have a special needs beneficiary who is getting government needs-based benefits, because you don't want to somehow hinder their benefits with the government. So
Okay.
we always say, okay, in those special circumstances, name the trust as the beneficiary of your retirement accounts. But other than that, leave those retirement accounts outside of the trust.
Okay. Okay.
Same
And
thing.
life insurance?
Life insurance, yeah. So life insurance is one where I say name your spouse as the primary. If your kids are of age, if they're minor, if they're at least 18, name the kids depending on the value. Now, if we have like $1 million policy
Yeah.
here, we
Yeah.
might want to give that some thought and think, oh, do we want like a divorce protection sub trust for those kids, or do we, because you don't want it to go out, walking off into the hands of a divorcing spouse, do we
Yeah.
want an asset protection sub trust set up for the kids? So in those cases, I would name the trust as the beneficiary. But other than that, I generally, especially with the surviving spouse, name the spouse as the primary, because it's just less rigmarole for the spouse to deal with when they're collecting the proceeds.
Okay. Okay. Well, we have a ton to talk about, so this
Yeah.
it's gonna be good.
Good.
You're gonna probably wish you didn't tell me all this stuff. So
No, I love
okay.
this. This is great. I love talking about it all day.
And then, so what's your approach when you first meet somebody and you're building out a plan with them?
Yeah. So what I do is we have like this estate plan design meeting, and some clients are just coming into the picture saying, what am I like? What is this? Like,
Yeah.
I have no idea what a trust is. I help. So then we walk through the basics, and that's where it's kind of more educational. And I explain, like, what is a will? What does it
Yeah.
do? What is probate? Like, why are we even doing this? Who cares?
Yeah.
So that's kind of like, it just depends on the client's level. And then if they're ready to roll and they're like, we already thought about this, we want XYZ as our trustee, as our guardian, and then we're ready to roll, I take down all the info, we walk through the issues. And then what we do is we set a estate plan verification meeting. And that is the meeting where they meet with me, and we go through all of, and one of our staff, and they go through all of making sure I got everybody's spellings of their names right, birthdays, all the little things like that. And then going through their distribution provisions in their trust and making sure this is exactly what they want. And I don't want them to sign anything that they don't want to sign, that they're not comfortable with. So that's why I said this process can take 2 years, and I can meet with you every month and say, okay,
Yeah.
have you decided yet? Some people, I have a very sweet client who, she said, I'm just going to do some meditation on this, and I just need some time to think. And I respect that so much. And I told her, every time I go on vacation, I change my remote contingent distribution in case me and my family all die in the plane together. I'm
Yeah.
deciding, okay, I want XYZ charity instead of, ABC charity. So I get it. These are big decisions. So
Okay.
that's the next step, is this verification meeting. And in that meeting, the client also does a little bit of homework. Well, actually, before that meeting, they bring their homework to the meeting. So what that
Yeah.
homework is their assets. And so we ask for their asset information, and that is so we can fund their trust and help them
Okay.
with that. And so after that meeting, then we have as many more as we need, and then they're signing, they're ready to go. So once they're ready to go, we can get them in the next week, and they're in with our notary and our witnesses, and they're ready to sign their documents. And then, like I said, they're part of our client family for life, and that's just fun because
Yeah.
our goal is to have some client appreciation events, and and, really just stay a part of our client's life, because it's really a huge part of their life is this estate
It
plan, and
is.
things change. And so we want to be there for you.
Perfect, perfect. And so what are a couple examples like how somebody can maybe protect their kids or their and with a well-crafted plan, right? Like what are a
Yeah.
couple examples of how they could protect their kids?
Yeah. So one of the things that I'm not a big proponent of outright distributions, as I kind of alluded to. So I say that, think about, even though your kids might be teeny tiny, you don't know the people that they're going to marry maybe one day. At
Yes.
minimum, have something like a divorce protection trust set up for your kids. Now, my kids are 3 and 5 years old. Again, I have no idea if they'll get married one day, who they're going to marry. My own trust I have drafted as a divorce protection trust for the benefit of my children. And what that is they're getting their inheritance, if there's any left, who knows, at they're going to get it in a sub trust, and it's not established until me and my husband pass away, until you and your spouse pass away. The kids then inherit their estate in a sub trust, and
Okay.
it's a divorce protection sub trust, meaning it's going to always stay their sole and separate property. And so if something were to happen, there's a divorce,
Nice.
then it's staying with your child. And the beautiful thing about this trust as well is that even if they're with a spouse and they don't divorce, their trust, if your child dies, doesn't go to the spouse to then remarry and give it to somebody else. It goes to your grandbabies. It stays in your family, if there are any. If there are none, then it gets redistributed. And this is a conversation we'd have, because it doesn't have
Yeah.
to say this, but this is kind of okay, well, if we didn't have any other contingencies, this is what could happen and what would happen. If you have no grandchildren from that child and they pass away, it gets redistributed to a different child if you had any. And we would talk through, all the contingencies. So that's one
I
way to
like it.
protect. Yeah, it's a great thing. I personally really like it too. The other option is if you've got a child who might not be the best with their money, might not be the best managing their own estate. What you can do is set up an asset protection, or like a totally discretionary trust, so that the trustee has the sole and absolute discretion to distribute the assets to the child. And this could be done through you ask about how do you protect? Well,
Yeah.
you could have a private fiduciary, and I have a
Okay.
handful of fiduciaries that I recommend that I think are fantastic. I know that there's kind of this stigma with other people managing your money, but I have seen sibling relationships go right down the drain when you name a sister to be in charge of a brother's inheritance, and sister has to decide and use her discretion when she's comfortable distributing to brother who might be, a drug addict. And that is you do not want to put your children in that place,
That makes a
because
lot of sense.
it can cause so much family drama and strife, and oh my gosh. So that's another thing you can do to really protect. Get a third party neutral in there as your trustee. And like I said, I can, guide you to who those might be. So that's another way to protect. And so if you do this asset protection subtrust, that's the ultimate like vehicle of protection. So Nevada has really good like self-settled spendthrift trust laws, but California doesn't, which means we can't really protect our own assets that well, but we can protect our assets that are going to our kids when we die. And that's pretty cool. So we can do this asset protection subtrust for the benefit of our children.
Okay. You kind of hit on something there a minute ago. So when you can make it to where if they're not good with their money and it goes to a fiduciary, right? So say the fiduciary dies, but you have them in the trust. You're dead. The fiduciary dies. They were in the trust. Does it go with the corporation, or does it go with how does that work? Or does it get assigned to somebody else?
Great question. And that all depends on the terms of the trust. And so the trust that I draft, they say if there is nobody that's able or willing to that we've named that's able or willing to serve as trustee, then usually the way I draft it is the majority of income beneficiaries get to decide on who the trustee is. Some trusts can say, and I've drafted like this too, is instead of the beneficiaries deciding who that trustee is, the court can. Or you can have on just about all the trusts I draft a trust protector, and this trust protector can decide who the trustee is. So we don't have to petition the court for thousands of dollars to decide that successor trustee. So there are a few options. It will really just depend on what you want and what the terms of the trust say. But backup option, the probate code says, hey, if there's nobody, you can petition the court.
Okay. Yeah. I was just like, that person dies. And then I just start thinking.
Right. And, that's something to think about too. If you've got little ones and you're like, well, maybe when they're older, they might be trustee. Well, my goal is to give you your estate plan and never see you again for anything about estate planning, unless something major happens in your life where you really should be changing something. Yeah. My goal is to see you for family, fun events. But if you have little ones, what we can do is we can say, and I've done this a handful of times, I can say, I want my son and my daughter to be trustees so long as they're, 35 years old.
Yeah.
So that when they reach that age, you hope that they'll be competent enough to, be the trustee. But the first 5 letters of trustee are trust. Yeah. So you really want to trust your trustee. That's a big responsibility because they have to go in your house, right? And they have to go through your things, your personal belongings, to get everything out of there and sell your house and do all of the things like marshal your assets. And so you really have to trust this person. So yeah, for sure. And then so what would you say to put together a whole estate plan? Mm-hmm. What are you looking at cost-wise? We're just around $4,000 for if you have nothing in place right now. Now, if you already do, there's about $1,000 discount from that price. And then we're restating the trust. And when you restate the trust, you don't redate it. So you don't have to refund any of your assets. You keep your same date that you've had in the past. And then if you're just brand new and you're starting out with a family, you don't have too many assets, maybe a trust isn't right for you yet. I'll walk you through that. And our will packages are extremely lower. They're about $1,000. And we also, I just started offering payment plans because I realized, $4,000 is a lot of money. And for some people, it's just not something they have readily available in their savings account. So we do offer a year-long payment plan if that was of need for any client. Nice. Okay. And then a couple other things. You just brought something up. Okay. So you said will. So what's the difference between a will and a trust? Yeah. Or do you need both? Yeah. Great question. So when you have a trust, that is included in the trust package as a will. It's included as a property power of attorney, included as healthcare directives. A lot of stuff's included in that package. You get a 3-inch portfolio of lots of documents. If you don't get the trust, you'll get the will with all of those same documents except for the trust. So when you have a trust, you always have a will, because what that will is it's a pour over will. So anything that you have that is outside of the trust and you pass away. So if you purchase a piece of real property, forget to tell the title company that you have a trust and it's titled in your name, and this happens a lot, unfortunately, then we have to go to court, not do a full probate, but we have to go to court and ask the court to put that piece of property into the trust. And the vehicle, the mechanism to get it to the trust is that pour over will. Because that will doesn't say your assets go to your children. That will says that all of your assets go to your trust. So that's how it gets it over to the trust. Now, if you have a will, that gets you to probate. So without a trust. Okay. So if you don't have a lot of assets, that's why I say, if you're just starting out in life, but you want to name your guardian for your minor child or something like that, maybe just a will, because any of your separate property under the laws of the state of California, if you die without a will, it's not going all to your spouse, and which is crazy, right? Like you think, oh, it's going to go all to my spouse, but it's not. It's going to go half to your newborn baby if you have one baby and a spouse. And so you do not want your newborn baby inheriting something, because what that means is it's 18 years of guardianship through the courts, and that's very expensive.
Wow. 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 Yeah, for sure. Right.
Your 18-year-old inheriting, a lot of money. And then, I mean, you think of yourself at 18 years. What would I do at 18 years old? I would have probably bought a nice car or something.
Yeah.
Like,
Yeah.
you don't want to do that. Probably
No.
not going to be making the best decisions at 18 on your 18th birthday.
You would end up like one of those childhood actors.
Yeah, right. And it could be devastating. Yeah.
So you mentioned a couple other things, which is that I kind of want to dig a little bit deeper on. You mentioned healthcare directive. You mentioned durable power of attorney.
Yeah.
And you also those two things. So what is the healthcare directive that you brought up?
Healthcare directive, that is where you are asking your agent, so somebody that you trust, to make the decisions that you've checked on a document that says basically, do you want to prolong life under all reasonable measures, or do you want them to have the ability to pull that plug if it makes sense? Or you can leave it up to your agent. So the third option is, you know what, I just can't make this decision. I'm going to leave my agent. I'm going to have my agent make this decision. So that would be one of the things that is on your healthcare directive. Okay. Another thing is are you an organ donor? So you could have it on your driver's license. You could also have your body or have it registered with there's like a California depository registration.
Yeah.
You can register there. You could donate your body to science. This healthcare directive though states your wishes. Another thing that a healthcare directive does is it tells your agent, its instructions for your agent to like not do things. So for instance, we can write in Jehovah's Witness language, which is like, do not do any blood transfusions, for instance.
Okay. Yeah.
There's also like, we've done Catholic last rites, and they want, all of the Catholic language in their documents. So we do religious language as well in those documents. And you can write if you want to be buried, cremated, if you want your ashes scattered in Hawaii. Just on a real quick story, we had a client who said, my mom, she told me before she died, she wanted her ashes scattered in Maui. Can I use trust money to do that? And I said, did mom write it anywhere? He said, no. And I said, well, without the consent of all your siblings, that is going to be really hard to do. And he's like, I'm not going to get the consent of all my siblings. I know that. And I said, well, it's not going to be a trust trip then. It's going to be a moral obligation by you trip, which is terrible. So you really want that, like, because now he has to pay for it. He has to go, he has this moral obligation to go scatter mom's ashes in Maui. And so you really want that written down somewhere so that you have a reason to, use those trust funds to do that. So that's the healthcare directive.
You could just send it to send them to somebody like on the beach and be like, hey, will you open this up?
Right. Yeah. Well, and the wild thing is I learned there is a service that you can just send the cremains over to it was Kauai. We found and they will take it on a ship and they'll do a whole like little service for it, and you do not have to go. They were doing that with COVID, where you could just send the cremains and do that, and they give you a nice certificate. It's really a beautiful ceremony.
There is something for everything, isn't
there? There is. Yeah. So you really want to get those wishes, written down.
Yeah. And then now probate. So if you don't have any of this stuff, if you don't have I guess if you have the will, you're going to go to probate no matter what.
Yeah, absolutely.
Okay? But if you have a trust, you don't go to probate.
That's the goal, right?
And what is probate?
Probate is a court supervised process, and it is the process of getting somebody appointed to handle your assets, to take over, and then they can't distribute it out without a court order. So it is in the state of California before COVID, average probate proceeding lasted 16 long months. And now with COVID, we're just, seeing all the extended court times. And so it's about a 2-year long process before you're going to get anything distributed. Now you can go in and request a partial distribution, but that adds expense. I mean, I don't see those a lot. We're going in on one that's about a 5-year long probate right now. We're finally requesting a partial distribution just because we haven't sold all the property and there's some issues there. It is expensive for the estate. It's a lot. And if you don't have somebody appointed, that can be a real big issue. I have a probate going on right now where Gentleman passed away, 2 minor children. He has an ex-spouse and then a partner. He was never married. Well, guess who wants to take control of his estate? His ex-spouse. And that, is going to be a nightmare because the ex-spouse, has no, we don't have to go there, but
Yeah.
we're very concerned about, what's going to happen if the ex-spouse gets her hands on it. And so, that is not the decedent's hope that his ex-spouse was going to have, manage his estate when it seems to be a pretty contentious divorce. So we're trying to get in there, but he had nothing in writing. And so the other thing is now his 2 minor kids, we're going to have to do this guardianship thing, and we're going to have to, it's too bad. It's a shame. So
if you have, what would you say kind of your minimum amount? This is kind of just a random question, because earlier you said like, hey, it's $4,000 or whatever.
Yeah.
What would you say kind of your minimum amount of assets that you may want to have in order for it to become beneficial to you?
So generally the 2 questions I ask when someone says, well, do I need a will or do I need a trust? And so the 2 questions I ask first off the bat are, do you own any real property in the state of California? And the second question is, do you have minor children? If the answer to either of those is yes, you want a trust.
Okay.
Now, that's because you can't really get you cannot avoid, you can if you do some tricky things, but it's really hard to avoid a probate if you have a house or if you have any real property in the state of California. It's pretty difficult. But if you have minor children, they're going to have to go through a guardianship. You just want to avoid that with the guardianship of the estate if you can. So getting subtrust set up for those kids so it's all out of court would be great. Now, when you're talking about an asset value, the statutory limit in California is 166,000. If I'm remembering right, I think they changed the limit recently, but it's somewhere right around 166,000 before you have to go to court and petition. But that is only for personal property. So if you have real property that's even under that, you still are going to have to go to court. So that's generally the ballpark. So that's why I said, if you're starting out and you don't have anything, just get a will. Just at least get a will.
Just something.
Even if you're homeless, living under a bridge, you probably want to pick the person that's going to be making your medical decisions for you, because you don't want the doctor doing that. You want to have your wishes in writing.
Yeah. Okay. All right. And is that what you would call like a trust administration, or what is?
The healthcare directive would be that is actually part of the healthcare document. So that'll be the advanced healthcare directive.
Okay.
So trust administration means someone is incapacitated and we have to administer their estate for the incapacitated person's benefit, or somebody has passed away and we have to administer the estate for the benefit of those trust beneficiaries.
Gotcha. So that's kind of having a third party take care of that for you.
Exactly.
Perfect. So if people wanted to find it, like if people want to get in touch with you and want to find out more about your services and all that stuff, how would they get in contact with you?
They can come to our website. It's californiatrusts.law. They can also email hello@californiatrusts.law. And I can also provide you my contact information, but I'm happy to meet with you.
That was trusts with an S, right?
Yes,
trusts.
plural. Okay. Yep. California Trusts.
Okay. Awesome. And then now you're located in Roseville?
We're here in Roseville. Yeah, we're right by the John Adams Academy, Lead Hill and Harding.
Okay, perfect. Well, thank you so much for jumping on with me. I seriously appreciate it.
Yeah, this was great. This was so fun.